24-hour rule, Statement of Rule 5 rights, and our plea of not guilty to the charge. Understanding that the state is asking that Ms. Herring be held without bail, we have no objection to that request pending reservation of rights to challenge it after a weight of the evidence hearing.
Okay. Are you requesting a weight of the evidence hearing, or will you file a motion if you wish a weight of the evidence hearing?
We will file a motion if we wish to have such a hearing.
Okay. So unless I get that motion, we won't go ahead and schedule that.
Correct.
Okay. I assume the state is asking for a hold without bail?
Yes, Your Honor. I filed a motion specifically noting that the state was making that request, seeking to have her held without bail. This is a life felony.
I do, Your Honor. We'd waive formal reading of both together with the 24-hour rule, Statement of Rule 5 rights, and our plea of not guilty to the charge. Understanding that the state is asking that Ms. Herring be held without bail, we have no objection to that request pending reservation of rights to challenge it after a weight of the evidence hearing.
Okay. Are you requesting a weight of the evidence hearing, or will you file a motion if you wish a weight of the evidence hearing?
We will file a motion if we wish to have such a hearing.
Okay. So unless I get that motion, we won't go ahead and schedule that.
Correct.
Okay. I assume the state is asking for a hold without bail?
Yes, Your Honor. I filed a motion specifically noting that the state was making that request, seeking to have her held without bail. This is a life felony. It's a very serious crime. Ms. Herring is additionally suspected of involvement in 3 additional homicides. Those are currently under investigation as well.
Okay. Then, based upon the agreement of the parties, first of all, Ms. Herring will be held without bail. Mr. Slay, is there any objection? There were additional proposed conditions. The condition that would seem to be the most relevant, given the hold without bail, is the no contact with the Sobel family or employees of DCF unless it's in connection with a family court hearing. Is there any objection to that condition?
No, Your Honor.
All right, so the court will impose that condition as well. I think the rest of the requested conditions are probably not necessary given the hold without bail.
I agree, Judge.
Okay. Any other issues that we need to take up at this time?
Your Honor, I have received a motion from Mr. Slay to seal DCF records relating to the defendant. We would like 10 days to respond to that.
Yeah, I was going to give you 10 days to respond.
Additionally, having reviewed the facts of the affidavit of probable cause, the state is requesting that Ms. Herring be evaluated for competence pursuant to the statutory provisions, particularly 13 VSA 4814.
Mr. Slay?
You know, we'd oppose an order for a competency hearing at this point. We think that the competency evaluation...
The assessment?
Pardon me?
You're opposing the assessment, not a hearing?
I'm opposing the assessment, correct. The assessment itself, post-arraignment, is part of a critical stage of the prosecution. It impacts Ms. Herring's right to counsel and effective assistance of counsel. The case at its infancy at this point simply provides me insufficient information to adequately represent her even during the assessment. So we would at least ask for a stay until such time as the state makes its Rule 16 production, which I would assume would be within the next 14 days, and then allow myself on behalf of Ms. Herring to either file a motion in continued opposition or notice the state that we no longer have an opposition.
Okay. So under the statute, if you raise the competency issue, the court does have the discretion to at least order a competency assessment at this time.
Yes.
Do you want to address it any further so I have a basis to order it, or do you want to reserve on that? Obviously, the issue can be raised at any time as well.
Your Honor, I think at this point we're going to rely on the information that's in the record already. If we develop additional information that specifically addresses competence, we will certainly bring that to the court's attention.
Okay. Then let me just say, I've certainly reviewed the affidavit of probable cause at this point, but I suspect there is a lot more information that's out there at this time, so I will hold off ordering any competency assessment at this point until the issue is formally raised by motion with the defense having an opportunity to respond to it.
Thank you, Judge.
Thank you, Your Honor.
So, if I can just weigh in on one other issue. The discovery in this case, I suspect, will be voluminous and ongoing. I guess I'm just urging the state to do whatever they can to expedite the law enforcement portion of the case and the lab portion of the case to get the information to your office as soon as possible in duplicate forms, so that copies of the books, which I think you're going to receive, can immediately be turned over to the defense, so that the one thing we don't have to deal with in the case are discovery delays with that.
Judge, we're certainly going to proceed as quickly as we can with discovery. There is the matter that there are related, potentially ongoing investigations still. We certainly are not going to do anything that would negatively impact those investigations, but we will certainly comply with our obligations to provide discovery in a timely manner.
I understand. Okay. And finally, with respect, Mr. Slade, to your motion with regard to the records, I am going to give the state 10 days to respond to that, and then make a determination about whether it's something I can simply rule on my own, or whether we need to have a hearing on it. Let me simply remind everyone that there are certain family court proceedings that are confidential by statute, and certainly the expectation is everyone will follow the confidentiality statutes. Everyone has an ethical obligation to do that. And we'll get the state's response, and then we'll decide where we go from here.
Thank you, Your Honor. I have one other request that I would make orally and, if necessary, follow up in writing. But to the extent that there have been any warrants issued in this case that have resulted in any returns, I would ask that they be provided to the defense forthwith, together with the warrant application materials.
Okay. I assume there's no objection to that.
There's no objection to that. We would be turning those over in discovery anyway.
Okay. Yeah. All right. So is there anything else we need to deal with?
No, thank you.
Okay.
Thank you, Judge.
All rise.